Application of the Convention on the Prevention and Punishment of the Crime of Genocide. Croatia vs. Serbia. Both parties involved in this case were members of the Federal Republic of Yugoslavia. Following the dissolution of this state emerged Croatia and Serbia and Montenegro, which is now referred to as Serbia. In 1999, Croatia sues Serbia in the ICJ under the grounds that Serbia violated the Genocide Convention of 1948. Croatia claimed in its application that Serbia had engaged in a form of genocide, which resulted in large numbers of Croatian citizens being displaced, killed, tortured, or illegally detained. Throughout the Croatian War, an estimated 20,000 people were killed. Article 9 of the Genocide Convention of 1948 states that disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide, or any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute. Croatia noted that Serbia signed a declaration in 1992 stating that they would abide by the commitments of their predecessors. Serbia stated that the broad language of the declaration was insufficient to bring them forth to the International Court of Justice. The legal issue at hand is whether or not a state that accepted the obligations of their predecessor is legally bound by a convention the predecessor had agreed to. The ICJ noted that the 1992 declaration made by the Permanent Mission of Yugoslavia to the UN, promising that the FRY would continue to fulfill all the rights conferred to and obligations assumed by the Socialist Federal Republic of Yugoslavia in international relations, including its membership in all international organizations and participation in international treaties ratified or acceded to by Yugoslavia. It is important to note that there is no international law forcing any state to adopt the legacies of their predecessor. Therefore, Serbia adopted the legal obligations voluntarily. The ICJ noted that Serbia's conduct after the FRY declaration makes it evident that they saw themselves as a nation bound by the convention. If Serbia did not want to be bound by the FRY declaration, they should have gone through the process of accession, not succession. This is made clear in the 1978 Vienna Convention of Succession of States. This convention makes it evident that treaties will not bind a state that it does not consider itself bound by treaties to which a predecessor state was a party. As a result, the court concluded that Serbia was therefore bound by the Genocide Convention and Article 9 in particular. This case is presently being heard by the International Criminal Court of Justice, with public hearings currently taking place until April 1st of 2014.